Okay, well, good morning and welcome to the next in our series of construction webinars. These are presented by the HCR construction team, and here we are in all our glory across our 11 locations, and we'll shortly be issuing the next set of dates for the upcoming webinars, which will feature new people from across the HCR group. But for today, there will be four of us talking for 10-minute slots. So Sadi, Gil and I will be covering the joys of the Building Safety Bill. Simon is going to be covering liquidated damages, and Thomas will be covering warranties in various shapes and forms. So hopefully there's plenty there for people to get interested in. There'll be time for Q&A at the end. If you can keep muted as we go along and use the chat function, and Simon will handle some Q&A for us at the very end. Okay, so I'm going to cover the Building Safety Bill. I'll give an overview. On the 14th of June 2017, a malfunctioning fridge freezer on the 4th floor of the Grenfell Tower in North Kensington started a fire. The flames spread unhindered along the exterior of the tower, with a resulting loss of life of 72 residents. The tragedy spawned a series of construction industry and government level inquiries, with the conclusion that the building safety system in the UK was not fit for purpose. The conclusion was that there was a need for a more effective regulatory and accountability framework for greater oversight of the building sector, and also to introduce clearer standards and guidance, and also to give greater powers to residents in regard to the management of risk and new remedies for defective or inadequate construction. And there was also a need to drive a culture change for a more responsible construction sector. There were some short-term responses. So government saying that the buildings above 18 metres of the Grenfell Tower kind, where you have what are called aluminium composite cladding materials, ACM cladding materials in use, which were not compliant with the building regulations, then that should be removed. That caused not an amount of understandable concern and alarm for residents of such blocks, along with their mortgage lenders. And the RSCS introduced the EWS external wall system certification process to try and assess risk in certain cases where ACM was being used. The Fire Safety Act has also been introduced, which allows for a total of 5.1 billion in funding to pay for unsafe cladding remedial works on buildings taller than 18 metres. However, the problem is, as the Ministry of Housing itself has accepted, there is potentially up to 473 buildings with ACM cladding systems which don't meet the building regulations. Could cost a total of 15 billion to put right, well ahead of the 5.1 billion that the government has contributed. And cladding is not the only part of the problem, because as cladding work is undertaken, other issues are being uncovered, non-compliant smoke systems, fire stopping systems, timber decking, and so on and so forth. So there's quite a few ongoing issues that will continue for some time, but the bill is about trying to look forward at least. The bill was introduced first in July 20 in a short form. A longer form was developed just this year in July. It provides effectively a framework with some direct new law, but there will be an awful lot of secondary legislation that is required. One of the key features of the bill is a core provision for a building safety regulator, which will be a new body to be part of the Health and Safety Executive, and which will underpin the proposed reforms. There will be two objectives for this body. First of all, to secure the safety of people in and around buildings, and also to improve building standards. The regulator's functions would include to implement a more stringent regulatory reform for what are termed higher risk buildings, and to oversee the safety and performance of all buildings, including in regard to new building standards and changes to the building regulations, and generally to drive a greater degree of competence in the construction industry, particularly amongst building inspectors. In terms of what is a higher risk building, which is a term which is regularly used in the bill, The Grenfell Tower factor means that this is currently defined as a building which is at least 80 meters in height or 7 stories, and which fits a particular set of descriptions set out in a separate set of regulations known as the higher risk building regulations, which itself includes a building which is containing at least 2 residential units, a care home or a hospital. Now, what is categorized as a higher risk building will be the subject of much debate, and already is indeed subject of much debate as the bill goes through Parliament, bodies such as the RIBA making the point that fire does not discriminate. In terms of how the bill operates, it manages new implementation in terms of design and construction of high risk buildings. There will be a new duty holder regime which will be akin to the existing construction design and management regulations, under which particular individuals involved in such buildings will have particular roles and responsibilities. And there's also to be a new planning gateway set up, under which for a high risk building there will be 3 gateways through which such a building would need to pass. Planning Gateway 1 is in fact already in effect as of the 1st of August of this year. Planning permission for a high risk building will need to be in a prescribed format, including a fire statement signed by a competent person setting out the fire safety strategy for that building. Gateway 2 has to be passed before construction can start, involves an application to the building safety regulator with full design intent. Building cannot start until the regulator is satisfied as to compliance with regulations, and also a demonstration as to how fire and structural safety will be addressed. And Gateway 3 is the completion final certification phase, when work on all such building is finished and the regulator assesses whether or not work has been carried out in accordance with the signed off consent. These are in effect to be hard stops in the process of constructing such buildings. This will increase the monitoring. It will also inevitably increase the time and cost involved in such projects. And in terms of recovery of what is going to be a lot of cost, government is currently consulting on a proposed building safety levy for England, which will apply at Gateway 2 for higher risk buildings. There is separately consultation for a residential property developer tax, which government is consulting on, and which will apply to the profits of the largest residential property developers, with a view to defraying some of the costs of removing unsafe cladding from leased residential buildings. In terms of responsibilities for high-risk buildings in occupation, there are to be new duty holders in the form of an accountable person and a building safety manager. There will also be obligations on the residents themselves. The accountable person is to register a building within the scope of the new regime before it's occupied. Existing buildings which are already occupied will have to be registered within a transition period. The accountable person will have to apply to the regulator for a building assessment certificate, which will be issued only when it's satisfactorily demonstrated that statutory obligations are being complied with. The job of the building safety manager is principally to support the accountable person in the day-to-day management of fire and structural safety in a building. The building safety manager can be an individual or an organization. In terms of the responsibility of occupants, residents must not act in a way that creates a significant risk of building safety, mustn't interfere with safety equipment in common parts, and will need to comply with requests from the accountable person, for example, for inspections. And the accountable person will have powers to apply to the court for orders where there is non-compliance and non-adherence to requests. Information was a key theme to the Hack inquiry in terms of information about a building, described as a need for a golden thread of information that allows you to understand a building and the steps needed to keep both the building and the people within it safe now and into the future. And the bill addresses this in a number of different ways, but there's also to be a new set of golden thread regulations which would effectively set out the principles and the parameters and the guidance and responsibilities that will go with that thread of information that will be required. Some of the more controversial elements of the bill you may have heard and read much about, which would include the building safety charge, under which the landlord's safety duties can be defrayed in terms of costs being passed on to tenants. Equally, remediation works costs are also, under the current provisions in the bill, something which can be passed on in part to tenants, albeit that landlords will be expected to take reasonable steps to ascertain whether, for example, there was a grant payable for remedial works, or whether costs can be recovered in some other way, for example, through insurance. The issues with that element of the proposal has been subject to much criticism. There are lobby groups involved, very unhappy about the pressure being put on to leaseholders. The Polluter Pays Amendment, you may have read something about, and at the moment the government is giving serious consideration to this, revising the previous obligations and provisions which I mentioned. Under this amendment, effectively, the government would fund the cost of remediation works akin to how environmental contamination is dealt with. The government would then look to recover that cost from liable parties, whether that's developers, contractors, manufacturers, or warranty providers. That provision actually goes much further and would address a range of provisions in the bill, putting more of responsibility onto the construction and development industry itself. In terms of enforcement, regulatory enforcement will be given to the building safety regulator, with extended powers to enforce non-compliance with the building regulations under sections 35 and 36 of the Building Act. And this would include extended periods of time for prosecution. Developers, in effect, could face up to 2 years imprisonment plus unlimited fines for non-compliance, and there'll be extended periods of time within which prosecutions can be undertaken. Building control is also subject to the bill. The bill talks a lot about improving competence levels. There is to be a new regulatory structure under which the building inspector and building control approvers will need to be registered, and quite a bit about new ranges of powers for the regulator to control and enforce building regulation compliance, a new portal of information for registered building control approvers. In terms of construction products, at the moment we are still subject to the EU-based regime, under which only around 400 product families are subject to registration. The bill proposes to extend that much more widely under a new construction products regulator, which will cover all products marketed in the UK, with new civil penalties and criminal offences enforced by trading standards for non-compliance, and also with powers of sharing information about products with the building safety regulator. Architects also feature in the bill. The Architects Registration Board will have extended powers in regard to the monitoring of registered architects, and architects will be expected to undergo continuing professional development, unlike at present, throughout their career. The ARB would also be given power to set competence criteria, working in association with bodies such as the RIBA. An architect that fails to meet those requirements or is guilty of professional misconduct or incompetence risks being deregistered and therefore not able to operate as an architect. Next, please. And also there is the new Homes Ombudsman. Effectively, a new body will be created under which complaints can be investigated and determined. Funding for the Ombudsman will be provided for under the bill, and in effect, all new home developers will be encouraged to sign up to what is going to be a quality management scheme aimed at providing a new forum for owners of newly built homes to seek redress against developers and also builders. Okay, next slide, please. In terms of a timetable for all of that, well, at the moment, the proposal is for the bill to become enacted at the back end of the summer in 22, but the bill will come into effect in phases, with a first phase of some of the provisions listed on my slide there coming into effect within 12 months, and the rest within by 2024. But as Sardeep will now cover, this is something which is causing not a quite understandable amount of concern amongst developers and insurers and others because of the changes to the civil enforcement ability and the retrospective effect of some of the new law. Okay, enough for me. Now over to Sardeep.
Thank you very much for that introduction, Colin. And as mentioned, I'll be covering over the next 10 minutes a brief overview of some of the additional proposals for the Building Safety Bill. So where does this come from? Well, the context is, of course, as Colin mentioned, the Grenfell tragedy and the subsequent cladding crisis, and ultimately the government seeking to provide some recourse to homeowners that found themselves in potentially stuck in unsellable, unmortgageable properties. And part of that response is, of course, the Building Safety Bill. So over the next few minutes, I'll be giving a short recap of the Defective Premises Act and then some proposed changes to the Defective Premises Act through the Building Safety Bill, moving on to the Building Act, and again covering some proposed changes. Next slide, please. So to kick off, the Defective Premises Act was a short piece of legislation that came into force in January 1974. Described in the preamble as an act to impose duties in connection with the provision of dwellings and otherwise to amend the law of England and Wales as to liability for injury or damage caused to persons through defects in the state of premises. And what the Act does is impose a duty on a person taking on work, the meaning of the Act, in connection with the provision of a dwelling. And the duty is to see that work must be done in a workmanlike, professional manner and with proper materials so that the dwelling will be fit for habitation when completed. Next slide, please. And ultimately, those taking on work can face compensation claims from homeowners if a dwelling has not been built with proper materials that make it fit for habitation. Now, those parties under the Act that are classified as taking on work is potentially wide, but it can include developers and contractors. There's a current limitation period under the Act, which is 6 years from completion of a dwelling, or 6 years from the completion of any necessary remedial work. So far, so good. The Act appears fairly straightforward. This all makes sense. Next slide, please. However, there are, of course, some exclusions to the DPA, inroads into its application, which have been made by case law over the years. And this makes it clear why it's actually currently fairly difficult to bring an action under the DPA within the 6-year limitation period. So the first exclusion is this point about not fit for habitation. So a claimant making a claim under the DPA needs to show that inadequate work or materials has led to the defect, which in turn means the dwelling is unfit for habitation. So therefore, the DPA doesn't cover all defects in a dwelling or in a building. It's just those that render it unfit for habitation. So an example, what could render a building unfit for habitation? Well, a failure to comply with building regulations may render a building unfit for habitation. An example on the slides is Rendlesham and Bar. And in that case, the judge held that if at the time of completion, an apartment is such that the local authority has knowledge of its condition, it wouldn't approve it as fit for occupation under the building regulations. For example, due to a lack of a suitable fire escape, it's probably unfit for habitation. An important point is that the relevant regulations to be examined are those that are in force at the time of completion and not those that are in force at a later time, such as when the claim might be made. Next slide, please. Another exclusion is that the DPA is currently enacted. It only applies to provision of a new dwelling. So it currently does not cover works which are the enlargement or repairs to an existing dwelling. Third exclusion, well, there's a narrow net of liability, which is those parties caught by the DPA. So not every party involved in the construction of a dwelling will fall within the DPA's ambit. So, for example, a party that takes on work for another on terms that it has to do work in accordance with instructions given by or on behalf of another will be excluded from the scope of the Act, as long as that party carries out the work properly and either has no duty to warn the other of defects or has a duty to warn the other but discharges the duty. In addition, approved inspectors are not subject to the DPA's remit. So this is made clear in Lessees and Horningsley. The Court of Appeal concluded in that case that approved inspectors in the exercise of their building control functions do not owe a duty under Section 1 of the DPA. And so therefore, without collateral warranties or third-party rights, third parties will have little to no recourse against negligent approved inspectors. Next slide, please. So moving on to the proposed changes to the DPA. Well, the government plans to amend the Act by introducing the following changes to the Building Safety Bill. And perhaps the most important change is a longer limitation period. So this will change from 6 years to 15 years from completion of the dwelling, or in the case of remediation work, 15 years from the completion of that further work. And ultimately what this means is that homeowners will have a longer period to make claims under the Act. Of course, it only applies in respect of dwellings. The government's view on this is that as most cladded buildings with potential issues were built in the period 2000 to 2017, this change will mean that the lion's share of buildings facing issues and those residents within will be helped by the extended limitation period. Second change is the extended limitation period will apply retrospectively as well as prospectively to claims under Section 1 of the DPA. There are limits to this, so if a claim is to be made retrospectively, the Building Safety Bill provides that the extended limitation period will not apply to claims that have already been settled or finally determined. So this makes sense. Of course, you can't open up claims that have already been finished or finalised, and a claim must be dismissed if it breaches defendants' human rights. Third change, the scope of the DPA will be extended to work on existing buildings. So a new Section 2A is going to be inserted to extend the scope of the DPA, and this will cover works to any part of a building which contains one or more dwellings. And what this change does, it increases the scope of liability to include not just those who build new dwellings, this is the provision of a dwelling point, but also those who undertake any works to existing dwellings, provided that work is done in the course of a business. However, important to note that the exclusions mentioned previously still apply, and therefore this route under the DPA will not always be the most attractive. Next slide, please. And moving on to the Building Act, now this covers a wide range of building owners. As we know, building regs cover not just fire spread or habitability as the DPA, but a wide range of other points. And currently breaches of building regs in the Act can attract criminal but not civil liability under the Act. And this is due to the fact that Section 38 of the Building Act provides a statutory right of anyone suffering damage as a result of breach of building regulations to bring a civil claim. However, this provision, Section 38, although it's been on the books for a while, it's never been brought fully into effect and isn't yet in force. Next slide, please. So the government plans to bring Section 38 into force, and when it does, it will provide private individuals the right to claim damages where they suffer harm because work on a building has not met building regulation standards. The government intention is to bring Section 38 into force at the same time as the extended limitation period for claims under the DPA. And this is to be done within 12 months of the Building Safety Bill receiving royal assent. So the bill also extends the limitation period for claims under Section 38 of the Building Act to 15 years from the date of the breach. Important to note, however, that this change will only apply prospectively and not retrospectively, which is in contrast to the changes to Section 1 of the DPA. So, for example, the bill could provide a cause of action for cladding defects, which can be shown to have been breaches of building regulations applicable at the time the works were undertaken. It's not yet clear, however, that the extended limitation period will only apply to dwellings or residential properties, so this may be the subject of subsequent secondary legislation or further clarifications from the government. However, the proposals are likely to have potentially wide-reaching consequences for breaches of building regulations in the future, as claimants will now have a 15-year period to claim from the date of the breach. Next slide, please. So what can we draw from this? Well, as we've seen, absent collateral warranties, third-party rights, subsequent homeowners can have limited recourse for defects against an original developer, for example, outside of the DPA. And often defects can take some time to manifest themselves, so a change in the DPA limitation period provides some additional protection to homeowners. However, bringing a claim under the DPA is not a straightforward exercise. Evidential burdens aside, there's of course the uncertain nature of litigation, and coupled with time and cost that it inevitably will take. And this avenue won't be attractive to all potential claimants, therefore. Next slide, please. The changes to the BA, however, is a boost for claimants if they can demonstrate breaches of building regs at the time of construction. So once these provisions do come into force, this extension to the limitation period may open up a right of recovery for claimants that are seeking to bring claims against, for example, designers, contractors, developers on a range of issues. So this could concern cladding, external wall systems, fire safety failings. These may currently, of course, be unavailable due to the expiry of the 6-year limitation period. Therefore, construction professionals may have greater exposure to claims if the work they've carried out is subject to the extended limitation period. What will this mean in practice? Well, projects will have a longer tail life. There may be elevated risks, which could put upward pressure on the pricing of works, and also, of course, insurance policies that are required to allow work to proceed. A practical point maybe for developers or other organisations is to consider amending document retention policies to ensure ultimately the documents and information on new builds are retained for at least 15 years. Well, thank you very much for listening. I've got time to cover on this now. I'm going to pass over to my colleague Tom, who is going to talk on warranties. Thank you.
Thanks very much for that, Sardeep. Hello everyone, my name is Tom Nation and I'm a solicitor on the construction team. And today I'm going to cover some recent guidance from the Technology and Construction Court, which deals with the enforceability of collateral warranties. First slide, please. So just to summarise what we're going to cover today, I'll be talking about what collateral warranties are and why they're often used as part of the security package in construction and development projects. I'll then go on to talk about how collateral warranties are enforced, focusing on adjudication under the Construction Act 1996. We'll then go on to look at the implications of a recent case from the TCC, and that's the case of Toppan Holdings and Simply Construct, and what that's likely to mean for warrantors and beneficiaries in the construction industry. Next slide, please. So what are collateral warranties and why would you want them? Well, many of you, if you've acted as building contractors or as consultants, may well have given warranties in the past, or you might well have received the benefit of a warranty if you've been an employer or a landlord or even a property purchaser or a tenant. So apologies if any of this is covering old ground. But just to illustrate why collateral warranties are useful, I've got a diagram here which is showing a construction project under the traditional procurement model, but warranties are useful on other models too. And in this example, the employer is instructing a building contractor to do various building works, and the building contractor is in turn instructing subcontractors to do part of the works, and other parties are involved. You can see there's a consultant team involving an architect and engineers, and we've also got other characters like a funder and end users, purchasers and tenants involved here too. But let's consider what would happen if, for example, the employer or indeed funder or a tenant needed to recover losses which were caused by a defect in the works, and one of the subcontractors was at fault. Well, ordinarily there's no major problem with this because the employer can recover this from the building contractor as is a direct contractual relationship. The problem comes if for some reason the building contractor is unavailable. For example, if they're insolvent, as I've just illustrated with the red cross on the diagram. What the courts have said repeatedly is as there's no direct contractual link between the employer and the subcontractor, shown on the yellow arrow, then the right to recover is heavily restricted, if not entirely non-existent. So in all probability, and I've got a sad face just to illustrate it, the employer is likely to be left out of pocket here. Next slide, please. So the solution to this problem, or at least one of the solutions, is to use collateral warranties, and I've put those onto the diagram using the coloured arrows just to sort of illustrate that quite often there's a network of warranties in a project rather than just one. You know, for example, you might have the subcontractor giving a warranty to the employer and the end users, and the building contractor and consultants might give warranties to multiple parties too. But all a collateral warranty is, put simply, is a contractual link where a party warrants that the works it has done have reached a certain level of quality or a certain standard of workmanship. And that creates an enforceable contractual link, and whereby the beneficiary, if they need to recover losses for a defect, can go directly to the party responsible. Next slide, please. So that brings us on to enforcement of collateral warranties, and until around July this year, so quite recently, the general legal view was that collateral warranties were construction contracts within the Housing Grants Construction and Regeneration Act 96, and we'll just call that the Construction Act for now. And that view comes from the 2013 case of Parkwood Leisure and Lang O'Rourke, Wales and West. I will call that the Parkwood case. And why is that relevant? Well, if a warranty is a construction contract, then any disputes can be referred to adjudication at any time, and that comes from Section 104 of the Construction Act. And as many of you will know, adjudication is generally a much faster, cheaper way of resolving a dispute than going all the way to court. It's likely to take months to sort out rather than years. But from July, the picture's looking a little bit more complex than that. And that comes from the recent case of Toppan Holdings and Simply Construct, the Toppan case, where the Technology and Construction Court has suggested that actually, at least when it comes to the enforceability of warranties, we have a two-tier system in place. Next slide, please. So before I come on to the recent case, the Toppan case, we'll have a quick look at the older legal position in the 2013 case of Parkwood. And I've summarised the facts of that case on the left with a little diagram. But to summarise, Lang was a building contractor who was employed to build a swimming pool and leisure facility over in Cardiff. Parkwood leased that facility as tenant from an employer, and the employer was not involved in the subsequent dispute. But Lang gave a warranty, the collateral warranty, to Parkwood after practical completion, and sometime after practical completion, various latent defects were discovered in the works. And what happened after that is that Parkwood went to an adjudication to recover their losses, and the adjudicator gave them an award for damages. Lang didn't pay up, so Parkwood took the matter to court to enforce it, and Lang actually challenged the adjudication on the basis that the warranty wasn't a construction contract, and therefore the adjudicator had insufficient jurisdiction to decide the matter. So bear in mind here that the warranty was given after practical completion, so after the works were all done. So the court had to look at whether the warranty came within the scope of construction operations, as the Construction Act puts it. And what the court found here is that the meaning of construction operations is actually pretty broad, and the timing of a collateral warranty isn't critical. So it could be given retrospectively, as it was here, and luckily for Parkwood, the adjudicator had jurisdiction. And as far as most construction lawyers were concerned at that point, collateral warranties were construction contracts, and adjudication was still available. Next slide, please. But having said that, the judge did add, sort of as an aside, that there could be certain circumstances in principle where a retrospective warranty wouldn't be a construction contract, and therefore adjudication wouldn't be available. And I don't really have time to go into all the nuances of that case, all the details of the judge's legal reasoning, but this was explored in more depth in the recent Toppan case, where we can see the picture is more complex, and I'll come on to that in a moment. Next slide, please. So coming to the case of Toppan, which was given in Judgement, which was given in July, the main facts of that case are on the left, again with a diagram, and simply was a building contractor, and they built a care home for Toppan, who leased it out to another company as landlord called Abbey Healthcare. After the works were all done and the home was up and running and open, and after practical completion, various defects were identified, and Abbey went and obtained a collateral warranty retrospectively from Simply. I should add, Simply weren't overly keen to give that warranty. They had to be forced by Toppan using a High Court order, but they did get the warranty, and similarly to in Parkwood, they took the matter to adjudication. The adjudicator gave an award for damages, and when Simply didn't pay up, they took the matter to court to enforce the adjudicator's decision. Again, the court had to look at whether retrospective collateral warranties are construction contracts within the meaning of the Construction Act, and therefore whether the adjudicator had the relevant jurisdiction. Next slide, please. So what did the court find here? Well, actually in this case, the court declined to enforce the adjudicator's award, and there are a number of reasons for that, but the important point was that the works had all been completed by the time the warranty was given, and other contractors had come in and rectified the various problems. So the court felt really that the warranty was referring to a past state of affairs rather than to future obligations, as it was in Parkwood. So in terms of where that leaves us now, we'll look at that on the next slide. Before I say that, I'll just say that the claimants are planning to appeal this decision, so the position is a bit uncertain and we might well have to return to it in the future. But at least for now, it would seem that the timing of warranties is actually pretty critical to how they're going to be enforced. And if they're executed when works are incomplete, the court said that that's a very strong pointer that they are construction contracts. If they're done after practical completion, then it's unlikely that they are construction contracts. Next slide, please. So just a couple of points then, just to wrap up, a few points you might want to think about going forward. Warranties are often seen as a bit of a sideshow or an afterthought to the main building contract or to the main appointments. But I think what this case tells us is actually there could be a few issues that need a little bit more consideration. And we do advise people on this quite a bit, but mainly what we're talking about are the terms of the warranty and the timing of the warranty. So perhaps have a think about any projects that you might be involved in or expect to be involved in where you're giving or expecting to receive a warranty. When's that warranty going to be executed? Have you thought about your options should you need to enforce the warranty? Do you need perhaps something built into the contract or even into the warranty that gives an express right to adjudicate or ensures that different parties execute the warranty at particular times? Have a think also if you're involved in anything where there's a funder involved in the project. It's quite often in those projects the warranties are not given until the end after practical completion. So is that going to affect the value of the warranties to the funder if they're enforced differently? And is it possible that parties are going to get reluctant to give warranties on a live project? Do you need any advice on what that means for you going forward? And finally, I'll just touch on the topic of insolvency and step-ins, as it's a huge topic and we could have a whole talk on it in itself. But just have a think, that is it possible that if a warranty is given before an insolvency event, that depending on the state of the project at that point, where the works have got to, that it might have different enforceability to a warranty given after the insolvency event? But that just about wraps up what I want to talk about today. Thanks for listening. I'll come to any questions if I can at the end. Otherwise, I'll hand over to Simon, who's going to talk a bit about liquidated damages. Thank you.
Great. Yeah, many thanks, Tom. As Tom said, my name's Simon Wayne. I'm a partner in the ACR Hewittson's team. I'm going to cover some various topics around liquidated damages, some of which may be pretty familiar, but also looking at sort of recent developments and how the law on liquidated damages has developed over recent years. So first slide, please. Just going back to basics, really. What are liquidated damages? They are, and looking, specifically, obviously, in the context of construction and engineering contracts. So they are predetermined damages for specific defaults. Most commonly, failure to complete on time. So most construction contracts obviously will have a target completion date in them. And if the contractor fails to complete by that time, may have to pay a pre-agreed rate of predetermined rate of damages up until the actual date of completion. Quite commonly also in sort of plant engineering contracts, both process plant and mechanical and electrical contracts. You also see very commonly liquidated damages for failure for the completed works to meet certain standards. So the ICME, the MF1 forms use that. There is an option in NEC3 to do that. So for each unit that the completed plant falls short of the pre-agreed outcome, a sum will be payable by the contractor, I should say. These are most commonly, most usually capped, because otherwise, the risk and exposure of the contractor could be immense. But that's a very common thing as well. Next slide, please. So as I say, the liquidated damages are paid at the pre-agreed rate for the period that the failure occurs or for the amount that the plant falls short of agreed projected output. And this has been, they've been used for many years in this way. Next one, please. One query which is quite often raised is, are liquidated damages an exclusive remedy? Now, obviously, this very much depends on the wording of the contract. Some contracts may explicitly say, for the default of delay of being late, this is all the contractor is exposed to. Some may explicitly say, no, not only will you be paying liquidated damages, you'll be paying a sum on top. Query whether that then becomes enforceable and whether the liquidated damages clause becomes a penalty, and I'll look at some aspects around that later on. But I think it's generally held that in most contracts, as in the JCT, that they are an exclusive remedy, even though the JCT actually doesn't make it completely explicit that this is the case. But traps for the unwary, the employer who put a rate of 0 against the LD column, it was found that even though the contractor was late on that, the employer was actually unable to recover any damages at all for that breach. Next slide. So come on to how are they calculated? How are the liquidated damages calculated? Now, the phrase which has been used for years and which we're all familiar with is that liquidated damages should be a genuine pre-estimate of loss. Although, as I'll explore later, and some recent developments on liquidated damages, that's not an absolute rule, and it's not quite as simple as that. It's a good place to start, but it's not quite as simple as that. What is important for the employer, and is going back to it being an exclusive remedy, so all the employer can charge if the contractor is late, or all that can levy is liquidated damages. The employer's got to make a very thorough assessment of what its actual losses might be. Some simple things, it's going to go on paying consultants if the contractor runs over, and the consultants can charge extra if they're doing a longer job than they bargained for, which is normally to be completely reasonable. So include those. An employer may have agreements for lease where it has to provide the building to tenants. Either it's not going to get the rent so early, or it may be liable in damages to the tenant. The tenant may be a shop which needs to open and is going to see its revenue, not able to realise its revenue until it gets a building. So it will seek to levy those on the employer, who will then seek to pass them on. Other matters, the employer, it could be a sports facility, and if it's delivered 2 weeks late into the season, that's 2 weeks of potential revenue lost. So the employer should be able to calculate that. I say it's got to be a genuine pre-estimate. It can't just sort of finger in the air and this is what we might do. On the other hand, it's not always possible to say exactly what losses may be suffered. So the employer really just has to do the best it can on that. The contractor will then be presented with those and will have a chance to look at them, negotiate them. Are they so high that the contractor can say, well, look, that's a penalty clause. That's not reasonable. That's not what you're going to lose. We know what you're using this for, and that's far too high. If the liquidated damages are a penalty, they're held to be unenforceable. Equally, the contractor may think, okay, looks fair enough, but we need to pass that down. Can we pass it down to our key subcontractors? How do we do that? With a subcontractor with one package, which, although it might have the capacity to make the contractor extremely late, it might be quite a small package, and the liquidated damages for the whole project may be completely disproportionate to that subcontract package. Or the contractor can also look and say, well, we know what we could be in for. Let's price that as a risk. Obviously, we don't think we're going to be 26 weeks late, but there's a few tricky things here, and we could run a couple of weeks late. So we need to give a price that reflects that. And again, that's something for the employer to look at too. If I give such a high price, am I going to get reasonable prices back from contractors who are pricing this risk? And next slide, please. The advantages are reasonably obvious of liquidated damages in that there is certainty. So the the contractor knows what it's in for, as I've said earlier, and can price that. It's not something which will come as a surprise if the contractor is late. Equally, the employer knows what it can recover in the event of default, and the employer then doesn't have to mitigate, which is really quite important in some cases. You know, if the damages are unliquidated, if it was just prove your loss, there might be a duty to find a tenant, an alternative site, play your match elsewhere, etc., etc. The employer doesn't have to do that. Next slide, please. Just briefly, and again, traps for the unwary, there are condition precedents to claiming, particularly on JCT contracts. Notices have to be given. These are administrative, but unless you do it, you can't actually deduct liquidated damages. So you've got to serve a non-completion notice and notice of intention to levy liquidated damages. Other contracts, maybe not so explicit on that, but again, just employer, it's important to check what the provisions are. Next slide, please. So coming back to you know, what is the rate of liquidated damages, and I said earlier, you know, genuine pre-estimate has been the sort of test that's been used, and to make calculations on what they are. But these sort of recent cases come out of you know, particularly some the car parking situation, where, you know, you're parking for a few pounds an hour, but if you overstay, you have to pay a £50 levy, and obviously that's disproportionate to a genuine pre-estimate of loss. And the court said, well, yeah, but fair enough, there's got to be some incentive to not leaving your car there all day. And the test is whether a clause imposes a detriment on the contract maker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. And further compensation is not necessarily the only legitimate interest the innocent party may have. So to put that in a construction context, it's easy to do in a parking one, is it may be that actually the employer isn't going to suffer a loss in the first few weeks, first few months, or maybe at all in getting the building, but obviously it's still got a legitimate interest in getting a building, and you know, it doesn't want to be in a position where it's got to prove its losses. So it is legitimate to say, it's almost a reverse incentive to say, look, if you don't get it to me by this date, I'm sorry, I'm going to have to levy damages. You know, that's now held to be, even though it's not a genuine pre-estimate of loss, you can actually levy damages in those circumstances. Next slide, please. This is an example in the sort of construction engineering field, is that there was a solar project. It was five solar projects, and the same damages were set in each contract on each project, even though they're very different sizes, different values, and the losses for damages, but the losses wouldn't be the same on each, the court held. Now that's enforceable. It's not out of proportion. It's a reasonable thing to do. Had the certainty, the contractor eyes wide open going into it, and to have sort of tried to fiddle around with the different amounts wouldn't have been in either party's interest. Yeah. At the other extreme, you can see how if there had been 5 different projects and they'd gone at the highest rate, and even the lowest one was at that rate, they may have come to a different conclusion. Next slide, please. And final point is a recent, this issue has come before the Supreme Court, a Triple Point Technology case, that after termination, after an employer terminates a contractor's contract, the liquidated damages can't be levied. You can see that's a pretty reasonable decision. It's even if the contract's been terminated completely validly and legitimately, the contractor no longer has control of when it's completed. So to continue doing liquidated damages when the employer can effectively take as long as it likes would not be particularly reasonable. And the employer has other remedies, and will be able to claim unliquidated damages from the defaulting party for its losses. So yeah, that's hopefully a sort of good refresher, and also looking at some of the recent developments on liquidated damages. And as others are, I'm very happy to take any questions.